Convicted rapist and murderer Thabo Bester's prison escape has been postponed to the 20th of June for further investigation. Bester appeared before the Bloemfontein Magistrate's court virtually from the Kgosi Mampuru, where he's being held. Meanwhile, the same court also postponed Dr. Magudumana's case of aiding and abetting Bester in his prison escape. Magudumana also appeared virtually from the Kroonstad Women's Correctional Center. Her lawyer says they are not yet ready to apply for bail, but should the situation change, they'll approach the court. All right, now let's get analysis. We're now joined via Zoom by legal expert Ulrich Roux. Thank you so much for your time this afternoon. Now, let's start at the very beginning. Bester's new lawyer, Advocate Pila, telling the court that they had not agreed for Bester to appear virtually, saying it was important for him to have consulted with his client physically in court. Just unpack all of that for us. And also, while we are there, Dr. Magudumana's father, Zolile Sekeleni, who's out on bail, appeared with 5 former G4S employees physically in court today, but like Bester, Magudumane also appeared virtually. Anything untoward about that?
Hi, good afternoon. Thank you for having me. No, certainly not. It was an application launched by the Department of Correctional Services, and the reason behind them requesting that they appear virtually was that they fear them being a flight risk. The charges that they are facing are assisting an imprisoned convicted person from escaping from prison, as well as fleeing the country in an attempt to evade their trial. So the Department of Correctional Services bringing that application, saying that it's in the interest of justice for them not to have to be transported to court, and that there are certain security concerns pertaining to that. The magistrate granted this application, saying that given the fact that these are very serious charges which they are facing, and the implications are very serious, and that there is a very real risk of them attempting to interfere with the judicial system, that he is willing to hear the matter virtually. And we've certainly seen a lot more of that in the industry of late. It does just make more sense if a matter is going to be postponed inevitably, that the matter is heard virtually without the Department of Correctional Services and the South African Police Services being burdened with having to transport prisoners from a certain holding facility to a court. So certainly nothing untoward about that. The fact that her father appeared together with the other accused today, remember that he is one of the accused in the matter. He has been granted bail, but he needs to attend every appearance in the matter until the matter is now finalized. So all the accused before court at the moment, Thabo Bester and Dr. Magudumana, their matter has been postponed until 20 June for further investigation. They remain in custody. Her father, meanwhile, has been released on bail, and the other accused are now bringing an application to be released on bail. They are, however, all on the same charge sheet, and their matters must be heard together on every appearance in this matter.
Ulrich, another thing I'd like you to iron out for us, Dr. Magudumana's lawyer also saying that they were not yet ready to apply for her bail, but should the situation change, they'll approach the court. What should we then make of her not yet applying for bail? She's been in custody for over a month.
Yes, remember that when a person applies for bail, they need to depose to an affidavit under oath. And once they depose to that affidavit, then that is their version that they are tied to until the matter is finalized. So I think a strategic move from her legal representatives, and I must say that I agree with it. In my opinion, if she had to apply for bail now, there's no way that she would get bail. Obviously, Thabo Bester, even if he was released on bail on these charges, he's still facing his period of imprisonment on the charges of murder and rape that he was convicted of. So whether he gets released on bail or not in this matter is neither here nor there. But certainly a strategic move on their behalf. They would want to conduct their own investigation as well, possibly obtain evidence in support of Dr. Magudumana's release on bail before they bring such a bail application. Also, they would want to see what transpires during the bail application of the other accused, in order to see whether there's any information that comes out of their bail application which could possibly assist her in successfully applying for bail. But at this stage, I must agree with her legal representatives. There's a slim to zero chance of her being released on bail now. So rather sit back, gather more evidence, gather more facts which will be in support of a release on bail, and then when you are ready, then bring the bail application.
Let's talk then about what we are currently seeing today. Of course, the court has adjourned for a short while. In as far as the bail application of the other 6 suspects, what we are hearing, today, the defense cross-examining the state witness who testified, in court last week that the accused persons should not be granted bail. What are some of your highlights in as far as what we are hearing in as far as the testimony is concerned today?
Well, remember that all of these accused are facing very serious charges. They are all being implicated in assisting a convicted prisoner by escaping from prison and undermining the entire correctional services system that we have, as well as the judicial system. So very serious charges that they are facing. I've been in court myself the entire day, so I have not had an opportunity to watch the entire trial the whole day, but I can tell you this, and that is that the charges that they are facing fall under Schedule 5 of the Criminal Procedure Act, which means that they must prove that it is in the interest of justice for them to be released on bail, which is a tall order in this instance, given that they have completely undermined the judicial system. So one would have to weigh up the evidence that is presented by the state during the bail application now and see whether the case which they have against the accused is of a strong nature, and whether the evidence that they have at this stage shows that they would be able to secure a successful conviction at the end of the trial. If they don't show that and the accused prove that it is in the interest of justice to be released on bail, then inevitably they will be released on bail. Numerous factors are taken into consideration, such as the personal circumstances of the accused, whether they have any previous convictions or pending cases against them, and whether there's any reason for the court to believe that should they be released on bail, that they would try and evade their trial, they would try and flee the country in order to avoid being convicted in this matter, as well as whether there's any chance whether they would be interfering with any state witnesses or with the judicial system should they be released on bail. In terms of Section 60, subsection A to E of our Criminal Procedure Act, they need to prove on a balance of probabilities that these circumstances do not exist and that they would not pose a threat to the judicial system, nor can they be deemed to be a flight risk. And if they successfully do that, then they will most likely be released on bail. But we must first see what further evidence is adduced by the state. And then, of course, the application is made by the accused, which means that they must show to the court through leading evidence, whether it's via affidavit or whether the accused testifying themselves in the witness box, whether it is in the interest of justice for them to be released on bail. And we would have to wait and see what case they do present after the state has closed their case to determine whether the magistrate will indeed release them on bail or not.
Ulrich, as we wrap up our conversation, there's something I'd like you to weigh on. Submissions on whether or not the media should record these live proceedings has been in the spotlight last week and again this week in the Senzo Meyiwa murder trial, and of course today in the Bester escape trial. Just talk to us about or weigh in on, the importance of having the media record, these court cases, particularly as it relates to just the severity, but also the interest, of the public. Of course, media are obviously saying that they would like to record these proceedings whilst not also showing some of the witnesses.
Yes, certainly since the Oscar Pistorius trial, we've seen more and more criminal proceedings being televised live on our news televisions, and certainly it has contributed substantially towards society becoming more educated pertaining to our criminal justice system, what happens in a court, the onus on the accused, the onus on the state, and all the important factors that are taken into consideration by the court. At the end of the day, however, it is still the presiding officer's choice or his decision whether to allow the media to broadcast these proceedings or not. If the presiding officer determines that it could frustrate the interests of justice or it could impact the interests of justice in the sense of some of the accused being made aware of evidence being led when they wouldn't have been made aware of that should it not have been televised, then the presiding officer will most likely not allow a live broadcast of the proceedings. But certainly, it has contributed to a large extent to our society and community being educated pertaining to these proceedings, and as long as it does not undermine the interest of justice, then one can expect that this will be the norm going forward. Of course, it is the more knowledge that society has about these proceedings, the better, in my opinion. It is both informative, but it also could act as a deterring factor for would-be criminals. Should these proceedings be televised live and there being total transparency through our media pertaining to what happens in our criminal courts. In this instance, the magistrate has determined that there could be no prejudice and that it would not interfere with the interest of justice should it be live broadcasted. And I expect this to be the case until this matter is finalized.
Ulrich, appreciate your time. Thank you so much for coming through. Ulrich Roux is a legal expert just weighing in on some of the court cases that we're currently seeing in our country and, of course, the Thabo Bester escape trial.